morning, everyone. My name is Natalie Christmas. I'm one of the board members here at the Florida Young Lawyers Chapter. We're really grateful that you've come to join us today. I have the pleasure of introducing our first speaker this morning, Judge Kathryn Kimball Mizelle. Judge Mizelle is a United States District Judge for the Middle District of Florida. After earning her law degree from the University of Florida, go Gators, she started her legal career right here in Tampa, clerking for Jim Moody of the Middle District of Florida. She went on to clerk for Judge Bill Pryor of the 11th Circuit and Judge Greg Katsas of the D.C. Circuit before clerking for Justice Clarence Thomas at the U.S. Supreme Court, a first for University of Florida graduates. She practiced as a prosecutor in the Tax Division of the Department of Justice, Special Assistant U.S. Attorney for the Eastern District of Virginia, Special Counsel to the Assistant Attorney General, and in private practice at Jones Day, where she focused on complex litigation and appeals. Throughout her career, Judge Mizelle remained closely connected to her home state of Florida, teaching courses at UF Law School, being an active member of the Florida chapters of the Federalist Society, and supporting her hometown community in Lakeland. For those reasons, she was an obvious choice when a seat on the federal bench opened up in Tampa, and in 2020, President Trump nominated her to be a district judge for the Middle District of Florida. Since taking the bench in 2020, Judge Mizelle has proven to be a fierce defender of the Constitution and a dedicated jurist. Those who have appeared before her know that she approaches every case the same way, with a relentless fervor to apply the law as it is, not how she or the parties thinks it should be. And anyone who knows her well will tell you that she exhibits that same dedication and care in all aspects of her life. The Tampa legal community is lucky to have both her and her husband, Chad, and we're grateful to have her here today. Welcome, Judge Mizelle.
Well, good morning, and thank you for those kind remarks, Natalie. Natalie did serve as one of my first law clerks, so I didn't pay her to give those remarks, but I appreciate them. Well, it is a pleasure to get to welcome you all to Tampa for the second annual Florida Young Lawyers Summit hosted by the Federalist Society. I hope it proves to be a wonderful opportunity for younger lawyers across the state to gather together and discuss important legal topics. I commend you for taking a weekend away from the beach to do so. This moment in the history of the Federalist Society, I think, warrants a pause for reflection. The Society was founded 40 years ago by a group of law students with a commitment to three principles. First, that the state exists to preserve freedom. Second, that the separation of government powers is central to our Constitution. And third, that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Although there was initially some debate about the name, some felt that perhaps the Anti-Federalist Society was a better capturing of the organization's goals. The founders eventually settled on the Federalist Society moniker. Soon after, the first student chapter conference took place at Yale Law School in April 1982. And since then, in the past 4 decades, a national organization has blossomed with over 65,000 lawyer members and student chapters at every ABA accredited law school. With that in mind, I don't think it's an exaggeration to say that the Federalist Society has profoundly changed the legal discourse. This impact is evidenced both on law school campuses and in the wider legal profession, particularly if one looks at the modes of interpretation employed by the judiciary, where now almost all judges would self-consciously begin with the text. Perhaps for this reason, Judge Robert Bork opined that the Federalist Society has done more for the health of the law than any other organization. Or, as Justice Scalia aptly put it in summarizing the Federalist Society's growth and influence, the Federalist Society's founders thought that they had planted a wildflower in the weeds of academic liberalism. Instead, it was an oak. And it's an oak that continues to provide shelter and support to the scores of young lawyers who are equally committed to its founding principles. Indeed, you're all the beneficiaries of those who grew this organization for the last 4 decades. So to open the summit, I thought I'd focus on a couple of the taproots of this oak, that is, the Federalist Society. Healthy roots, after all, are essential to continued growth. I'll then conclude with a few comments for young lawyers. Okay, the first taproot I want to discuss. The Federalist Society is passionately committed to the belief that the government exists to preserve the freedom of its people. One of the fundamental freedoms we prize is, of course, the freedom of speech. In fact, all of the Federalist Society's conferences and events are grounded in that very concept of the virtue of free speech. That is, that ideas must be articulated, critiqued, and refined if we hope to arrive at the correct, legally sound answer. The Federalist Society is at its heart a debating society, committed to the free exchange of ideas. It is not a lobbying organization. It takes no litigating positions on specific issues, and it does not endorse candidates for office. Instead, the Federalist Society sponsors fair, serious, and open debate about important legal topics. This organization is rooted in the foundational belief that when all sides are given a fair hearing, the best ideas will win on the merits. For that reason, it rejects the notion of cancel culture, an epidemic in our society premised on silencing those with whom you disagree. That mode of public discourse is no discourse at all. It is weakness of one's position. For if you cannot convince your fellow citizens of the merit of your argument, then perhaps you don't have the better argument at all. Unsurprisingly, the free speech values of the Federalist Society are wholly consistent with the First Amendment, guarantee that Congress shall make no law abridging the freedom of speech. As Justice Scalia explained, the first axiom of the First Amendment is that a general rule, the state has no power to ban speech based on the basis of its content. This rule, that there can be no content-based restrictions on speech, serves the following purpose: to protect and grow liberty by allowing for the pursuit of truth in all arenas, which in turn produces a better government and a better citizenry. This is why James Madison believed that the freedom of speech is the only effectual guardian of every other right. The founders believed that human reason and vigorous and open debate would lead to truth, and truth in turn would lead to justice, prudent laws, and right actions by individuals. The ability to discern what is wise and effective versus foolish and unproductive by engaging in free speech is fundamentally important where sovereignty derives from the people themselves. And that is exactly where our Constitution originates, from the consent of the people. Robust debate, such as that fostered and encouraged by the Federalist Society, is therefore not only inherent in the fabric of our government, but necessary for its success. Frederick Douglass said it better than I can. Liberty is meaningless where the right to utter one's thoughts and opinions has ceased to exist. It's no secret then that free speech has fallen on hard times. In a recent New York Times and Siena poll, only 34% of Americans said that they believed all Americans enjoyed freedom of speech completely. And 84% of adults said that it is a very serious or somewhat serious problem that some Americans do not speak freely in everyday situations for fear of retaliation or harsh criticism. No wonder. We continue to hear story after story of speaking events, including, ironically, the Yale Free Speech Forum, being disrupted and shut down by protesters. And just this past week in a Senate hearing, we watched a witness accuse a senator of opening up people to violence by simply asking questions. Simply posing a question is unacceptable. I highlight these examples because they demonstrate a deeper, more sinister problem lurking. That's a fundamental misunderstanding of the value of free speech. The importance of freedom of speech is to lead to truth through the crucible of reason, to allow others to learn, to discern what is good and prudent, and ultimately to lead to human flourishing. None of those goals are met when mobs harass speakers or intimidate questioners to make a point, as opposed to addressing the arguments on their merits. Quite the opposite, in fact. Freedom is sacrificed, knowledge is diminished, and the public cannot grow in virtue when it cannot hear the merits and the demerits of the arguments being presented. In contrast, the Federalist Society is rooted in a commitment to the freedom of speech and in the belief that a citizenry that's willing, ready, and able to do that and exercise their freedom of speech is the bedrock of a successful democratic self-government. Okay, second taproot. The Federalist Society advocates for an independent judiciary that exists to say what the law is, not what it should be. Now, as a federal judge, I wholeheartedly agree with that. If I were to do anything else, I'd be violating my Article 3 oath and depriving the people of their liberty. I'll turn first to judicial independence. Judges should not be beholden or accountable to anything except the law. That is one reason federal judges are appointed for life, precisely because the founders recognized the importance of judicial independence from political pressures. An independent Article 3 judiciary is a necessary safeguard to the Constitution. Threats to the independence are many, and they are all concerning. To mention just a few, and should be obvious to all, judicial independence is threatened when you have physical threats to jurists, disclosure of confidential documents, and overregulation of the judiciary by political branches. The independence of the judiciary thus depends on lawyers like yourselves standing up for the structure of our Constitution, regardless of these threats. Next, I'll briefly touch on originalism. That is, to accurately say what the law is. To do so, a judge must first know what the law is. And how is a judge to do that? Well, in our system, the law is written, and the process of writing laws fixes their meaning. Just as we would read a pamphlet written by perhaps a provocateur of the Revolution, according to how his audience would have understood it, instead of interpreting it, say, under our modern values, we must read a legal text according to how its audience would have understood it. The meaning is fixed then when the text is written. And that meaning is binding when the text is enacted into law. To accept that meaning is fixed, but to refuse its constraints, is to place judges above the law and allow judicial preferences to govern the liberties of the people. After all, it was the people that ratified the Constitution, and it is the people who elect the congressman and the president who together enact our laws. So when a judge goes beyond the meaning that those people fixed in the Constitution and that those people's representatives fixed into statutory law, he places himself and his ideas above the choices legitimately made by the sovereign, that is, the people. To be clear then, originalism is not preferable to other interpretive methods because of its outcomes. It is the best method because it ensures the judges faithfully exercise only the power they were given under the Constitution to decide cases and controversies. And that's why an independent judiciary matters. Not everyone is going to agree with the results that the Constitution or the laws require. And pressure on judges to rule against the requirements of the law risk undermining the judiciary's ability to say what the law is, and thus sacrifices the people's liberty. Thus, without an independent judiciary, the courts become yet another political channel to reach policy objectives of the current dominant forces. That is one of the reasons that the Federalist Society's core tenets is an independent judiciary, and why so many panels focus on originalism and textualism and how to do those properly. Okay, so those are the two taproots I wanted to just reground us on. I'll leave with a couple pieces of advice for young lawyers. First, you have to speak the truth respectfully. You must practice free speech with manners that effectuate and do not detract from the end goal. If you spend too much time on social media, you may begin to think that brash, aggressive, or rude behavior towards your intellectual adversary is the way to win an argument. It's not. In real life, logic and persuasion carry the day. The number of likes you receive is often not really correlated to how convincing your argument is. Instead, you need to focus on grappling with your opponent's arguments truthfully and fairly. Second, and this one's really important to me, do the deep, hard work of originalism and textualism so that the judiciary can do their job better. One of the influences of the Federalist Society, and it's a good one in my opinion, is that every judge at least begins with the law's text and structure. Most will want to know the original public meaning, and for many, that's where the inquiry will end. Preparing originalist arguments and textualist arguments is not easy, and it's time-intensive. It requires a deep understanding of the historical record, but I encourage you to do that because it helps the judges do their important job well. I'll end with this. You're the ones who control the future of the legal culture, and how will you handle that responsibility? And in another 40 years, will the young lawyers look at you with the same gratitude we have for the founders of the Federalist Society? We stand as the beneficiaries of their legacy, so let's leave this group and this profession better than we found it. Thank you very much.